So, hello to all. Myself Vandana Yadav, and I am working with LEXIS and Company as a legal intern. And today I'll be briefing you about judicial review, the term which keeps coming in the newspapers. The term, this theory of judicial review was originated and developed for the first time in the United States of America in a very famous case of Magbury versus Madison in 1803 by John Marshall. The term judicial review is one of the basic features of the Constitution, and as we all know that a basic feature, when something is a basic feature, it cannot be curtailed, or it cannot be, this power cannot be curtailed even by a constitutional amendment. So judicial review is one of our basic features of the Constitution of India. But what is judicial review? Judicial review is basically the power of the judiciary to examine the constitutionality of the legislations and the executive orders of both the central and the state government. If they are found to be ultra vires, that is violative of the Constitution, they can be declared as illegal, unconstitutional, and invalid by the judiciary. Why was judicial review needed? Though this term is not anywhere used in the Constitution, neither has been defined in the Constitution. But we have an object for this. The first is to uphold the principle of the supremacy of the Constitution of India. The second is to maintain the federal equilibrium, that is the balance between the center and the state. And the third is to protect the fundamental rights of the citizens. The Supreme Court used this power of judicial review in various cases, like the Golaknath case, 1967, or the very famous case, Keshwananda Bharti case, 1973. In India, we have the supremacy of the Constitution. There is nothing above the Constitution, and Constitution alone is the law of the land. Every organ, that is legislative, executive, judiciary, derives its authority from our Constitution, and the Supreme Court is the ultimate interpreter of the Constitution. The term judicial review, as I told you, has nowhere been used in our Constitution, but there are certain provisions of the Constitution which explicitly confer the power of judicial review on the Supreme Court and the High Court. And these provisions are, they can be found in Article 13, which declares that all laws are inconsistent with or in derogation of the fundamental rights. All laws which are inconsistent with or are in derogation of the fundamental rights, they shall be void. We have Article 32, the power of the High Court to issue writs for the enforcement of fundamental rights or any other purpose. We have Article 131, which provides for the original jurisdiction of the Supreme Court in center, state and interstate disputes. We have Article 132, which provides for the appellate jurisdiction of the Supreme Court in constitutional cases. We have Article 134A, which deals with the certificate for appeal to the Supreme Court for High Courts. We have Article 135, which empowers the Supreme Court to exercise the jurisdiction and the powers of the Federal Court. We have Article 226, which empowers the High Court to issue writs for the enforcement of fundamental rights and for any other purpose. We have Article 143, which authorizes the President to seek the opinion of the Supreme Court on any question of law or fact. What is the scope of judicial review? Basically, there are three grounds on which the constitutional validity of a legislative enactment and executive order can be challenged. The first is that if it is infringing the fundamental rights, that is Part 3 of the Constitution of India, Article 12 to 36. Second, if it is outside the competence of the authority which has framed it. And the third ground is that if it is repugnant to the constitutional provisions, that is, if it is violative of the constitutional provisions. It is clear that the scope of judicial review in India is narrower than that of USA, because the American Constitution provides for a due process of law, which is against our procedure established by law in India. Our Supreme Court examines only the substantive question while determining the constitutional validity of law. Now in the end, we'll talk about judicial review of the 9th schedule, because Article 31B, as we all know, saves the acts and the regulations which are included in the 9th schedule of the Constitution. which initially contained only 13 acts and regulations, but presently it has gone to 282 because of a very significant judgment of the Supreme Court in IR Coelho case, where the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. The court also held that judicial review is a basic feature and it could not be taken away by putting a law under the ninth schedule. So this was all about judicial review. Thank you. Hope you liked the video.